at the improvements and keeping up to, keeping what in line with what is happening in terms of reform of laws, available laws, not only in Barbados but across the globe. And there are a number of issues that come to mind in terms of the whole issue of the computer and the need to have computer misuse legislation, which 20, 30 years ago would not have been necessary. Issues like countries, governments sign various treaties. We had some of them, for example, when we were last here 2 weeks ago. And these treaties require the development of certain statutes to protect us against some risks that might be embedded in those treaties. And this is the whole area of law reform. The issues of money laundering and the matters with the OECD and the EU in terms of compliance with these various agreements to reduce those in the area of international banking and financing. So in a nutshell, these are the sort of things that we are looking to deal with in this piece of legislation, which is, I believe, fairly straightforward. The bill, the objects and the reasons would be to repeal and replace the Law Revision Act, to one, modernize the system of revising and consolidating and editing the laws of Barbados. Two, it makes provision for the laws of Barbados to be, as I said, in an electronic format and authorize such changes to be made as are necessary to facilitate the format. Three, provide for the preparation and publication of a revised edition of the laws of Barbados whenever the need arises. And I said that the last edition was probably about 10 years ago. I don't know if any honorable members have received their copies of the laws of Barbados, but obviously, as I said, they're already dated. And B, it makes provision for the review and reform of the laws by a law reform commission. And of course, it provides for related matters. So in a nutshell, and I will just briefly go through the certain aspects of this matter in terms of the bill. Clause 3 speaks, of course, in part 2, to the establishment of the commission. And it speaks to the commissioner, who will be an attorney, not less than 10 years standing, and obviously have experience in terms of the drafter. I don't know if the Honourable Senator Boyce will qualify in this respect in terms of the experience as a legislative drafter. Under Clause 4, it speaks to the duties and responsibilities that will be the responsibility of that individual in terms of consolidating the laws at intervals with which he or she thinks considered to be appropriate. And importantly, at 5, we're responsible for establishing databases of the existing cumulative edition and looking at any revised editions and a database of annual laws commencing from any repeal as appropriate. Clause 7 speaks to some of the things I spoke about earlier in terms of the clarification of language, shortening and simplifying the phraseology, in terms of correcting grammatical, typographical, and other mistakes and omissions in the existing copies of laws, and for that purpose to make verbal additions, omissions, or alterations not affecting the meaning of any law. To correct cross-references that in any law, and to correct punctuation, and to make formal alterations to the names, localities, as they may become necessary. It then speaks in terms of minor errors which the commissioner could rectify, and then there are errors of significance that the commissioner will advise the Attorney General of the order, and then the Attorney General to rectify the error by said not required amendments of the laws. So in effect, those are the sort of things that the Revision Commissioner will be involved in. I know that all honorable members would have had 2 months to review and to go through clause by clause in terms of the significance of this bill, and to have all of the queries researched and dealt with. So I'm not planning to delay the Honourable Chamber this morning too long in terms of the details. Suffice it to say that at Clause 29, it speaks specifically to the Law Reform Commission, and the person appointed to the Law Reform, they will have the Attorney General shall by instrument appoint the chairman and such other persons as appear to him to be suitably qualified pursuant to subsection 3, and it speaks under this section who holds or has held judicial office, or a person who is an experienced legal practitioner or indeed an experienced teacher of the law in a university. Again, that might apply to Senator Boyce. It speaks to the possibility of judges serving on this commission. And it goes on under Clause 31 to speak of the actual, that the Law Reform Commission will have the following powers: to receive and consider any suggestions or formal proposals for the reform of the law which may be made to the Commissioner, to undertake pursuant to any recommendations approved by the Attorney General the examination of particular branches of the law and the formulation of proposals for reform, and to obtain such information as to the laws and legal systems of other countries as appears to the Commission likely to facilitate performance of any of its functions. So in effect, you are giving the commissions the latitude to review other pieces of legislation existing in other countries. While I'm on that point, I should mention that this is not new to the Caribbean, that Jamaica, Trinidad, Dominica, and indeed the Cayman Islands are among countries already in this region who have gone in the direction of establishing the Law Reform Commission. And importantly, at Clause 33, the chairman of the Law Reform Commission shall prepare at the beginning of each year a program for law reform for that year and submit it to the Attorney General no later than the 31st of January that year. And I believe it goes on to speak in terms of this report, and it has to be laid in Parliament with comments of the Attorney General. So as I said, Mr. Deputy President, Mr. Deputy President, that it is fairly straightforward. I will sincerely look forward to sitting and listening to the more enlightened as regards this matter, this legal matter. I certainly look forward to that. And with those few words, I beg that this bill be now read a second time. I'm obliged to you, sir.
Thank you, Mr. Acting Deputy President. I'm going to make Senator Tate happy this morning. I'm going to actually support the government again.
The mic.
The mic is on.
Can't hear you.
I am going to support the government again for the second time today. I am impressed that they have actually kept a promise. That they've actually kept a promise. This promise to reform the laws has been long outstanding. I worked in the Attorney General's chambers years ago, and one of the functions that I had was to put in the loose leaf, up to date the legislation, and I could confess now that I did do a little side business for attorneys in Bridgetown who didn't know what to do, and I made a little bit of money from that. Mind you, that's a minor offense in the public service, and you can only get a warning. I was never caught. But suffice it to say that we had an ongoing law revision, but it didn't have the kind of, it was sporadic, thank you. It wasn't ongoing to this extent that a person was there all the time. I remember I came on when we had Miss Betty Bourne-Holland. She was the consultant who did the revision. And she did a lot of work. As I can tell, she did a lot of work because I got a lot of side business out of it. She produced a lot of work, and I think this country owes her a debt. The Law Revision Commissioner was the Attorney General, and she worked as a consultant doing the actual work. And she had a capable staff. I remember Ms. Stewart in particular. And they worked along with her and tirelessly to keep the laws updated. But it was a mammoth task because you had to come back from 1971 when the last actual revision was done and then keep updating the laws So you had a situation where they were working in deficit. They were always working behind. So we didn't always have the laws updated as we should. And I've noticed that they always complained about not having the amendments, because there was not ever enough time to have the amendments inserted into the laws so that people could actually know what the state of the laws were. And especially with the income tax amendments. Every year they have an amendment. And so sometimes you will hear a person arguing about an amendment about the Income Tax Act, and then you would know, sir, you would well aware, that there would have been an amendment to that in this budget, and then the next budget, and then the following year. They always had amendments, and you couldn't keep up to date. Know that we're going to have a permanent commission and a permanent law revision commissioner. I think that these things should be a thing of the past, you know. One of my main concerns was that the laws were not readily available. I remember they were available once on the CARICOM website. You know, you could not get the laws of Barbados in Barbados. And the only place available was the CARICOM website, and somehow the government decided that they shouldn't be there because they wanted to sell them at the printery, so that was taken down. And some of us had to find other ways to get them. I will not tell you how. Probably at lunch. They were not readily available, and the thing is, a lot of people get worried about the laws. The laws are written in English, and most times you just need to understand English comprehension, and you can understand what the laws are saying. A lot of people are afraid. But because they were in these blue volumes and they look ominous, people didn't go into them, and sometimes, you know, they're quite simple. So I am glad now that they will be not only in the blue books, you will have them online. One morning I saw something here where they said about paying. Well, you always have this paying thing. The law should be freely available. I can go online now and pull up any law for Trinidad that I want. The laws of Trinidad are online, free. I get them when I want them. But I'm still seeing something in here about payment. So I hope we forget that part about payment so that people will know what the laws are. You know, if you don't have, you don't got to pay for everything. As a matter of fact, you don't have money to pay for everything since the government has taken away every cent they had. So I am heartened, sir, and I am happy that the government has taken this step. You know, and I don't want to be long, and I'm not going to be long. But there is one aspect that I would like to, whoever the commissioner is, on his first task, we are speaking legally, so her is only in the Maternity Leave Act. Everything else is his.
Valid point.
One of the first tasks I would like the commissioner to look at the public service pension arrangements. He's supposed to look at the conflict of laws and make suggestions, or even, they say here, propose amendments to the bill. We have in that legislation, and I don't want to go too far into it, we have in that legislation where there's a provision that says, and that the courts have misinterpreted, that you can only get your pension at 60. And now, further down in the Act, at section 13.2, cap 25. And then further down at section 13.2, it says if you are in receipt, no, 31 says if you're in receipt of your pension before you reach 60, retirement age, the Governor General can call you back to service. Section 2 goes on, subsection 2 goes on to say, if you refuse to accept that invitation back to service, and you have not reached the retirement age, your pension will cease until you reach retirement age. And then there's a provision that says that you can't get it before retirement age. So these are conflicts in the law that I would want the commissioner to look at urgently, because they're very relevant today. Because, as I said, I don't want to go too far into it, because right now I have a gentleman who came to see me a couple of days ago. He's 28 years old. Yes. And the government has I can't say abolished his post or whatever. They have sent him home, retrenched him. And because he had 10 years service, he is now pensionable. But according to the misinterpretation that we have, his pension is due when he is 60, at age 60. The boy is 28. So you know how long he got to wait before he access his pension? Or because there's no severance payment for a person in that category, there's no severance pay, and there's no unemployment benefits for people who are appointed in public service. So these are some things that I want the commissioner to address. Because I was prepared to go to the ombudsman and ask him to do something about it. I even have the form. But now that we're having this law, commissioner, I hope you get it up and running soon, because that is one of the areas now in this country where persons are suffering, and it isn't one of the promises that you have in there, Senator Walker. This is one that is sneaking on us, and is doing great harm to the people of this country. So I'm hopeful that the law revision commissioner would wrap his mind around it very quickly and get to that. It is a problem that right now you're having people going home and not getting a penny from the government. You know, and there's another aspect of it, but sir, when we get to that debate, if the government ever brings it, Thank you, Mr. President. I was saying that when the government brings those things to the Parliament, I will get a chance to speak to them, but it would be fortunate to get them into this debate at this time. I will try, and I know I will be put down for it by some honourable senators, so I'm not even going to try. But suffice it to say that this piece of legislation is long in coming, and I compliment the government on bringing it at this stage. You know, I'm not here just to oppose. If the government is doing something good, I will say so. And this is a step in the right direction. And I hope that there are more steps in the right direction. Doubtful, but but this is one little baby step, and I want to compliment the government on bringing this legislation. So with those 2 words, sir, I thank you very much for your indulgence.
Who's next? Wiggins, Senator Wiggins, please.
Thank you, Mr. President. I too rise to support the government on bringing this law reform bill, and as pointed out by our honorable leader in the Senate, many bills had come to this honorable House, and we, especially Senator Tate and the new law commissioner, Senator Boyce, had made issues out of the errors that were made in the bills that came to this honorable House. And I'm very pleased to be able to support the law revision, the law reform and law revision bill 2018, and the appointment, obviously, of a new law commissioner. We know that laws are dynamic, and because the world is changing on a daily basis, almost daily, it is good to see even yesterday in the other place.
On a point of order, there's no law commissioner. She's misleading the Senate. The honorable member is misleading the Senate. There's no law commissioner, no such entity.
It is great to see even yesterday in the other place, you know, that the Honorable Prime Minister introduced new, in her statement, issues relating to the international business sector. So I think this is a very, very good move on behalf of the government to be able to reform and modernize, because when you have to interact with the international business companies in the various jurisdictions, you want to know that Barbados is compliant in every way. And I thought it was a very good move. And sir, I am here definitely to support that. And with those few words, I'm obliged to you.
Recognize another senator. We should speak. Senator Sanders, please. Please proceed.
Thank you, Mr. President. Good afternoon, Honorable. Good morning, Honorable comrades. I rise to support this law revision and law reform bill for 2018. When the Barbados Labour Party won the general election in May 2018, when the Barbados Labour Party won the general election in May 2018, a new dawn of a new day was upon us. There was a dawn of a new day. A dawn of a new day was upon us. Citizens of Barbados began to feel the era of hope. Hope was restored to Barbadian people. As soon as this administration came into office, they wasted no time. They got straight to work. They addressed the first critical issue, the economic issues of this country. They set a plan in motion which resuscitated, stabilized, and created provisions for the generation of growth in our economic activity in this country. But economic issues were not the only issues affecting Barbados. Our issues were not isolated to economic issues alone. Barbados in 2018 is operating as Barbados of 2008. There was a lost decade in this country. As a result of that, this administration recognized that it needed to lead Barbados through a transformational process whereby Barbados would be rebirthed. It would look, feel, function, and operate as a modern Barbados in 2018, a 21st century Barbados. And Mr. President, it is my view that I propose that this bill before this Honorable Senate today is one of the many steps that this administration has to take in terms of transforming Barbados into a modern society. The Law Revision and Law Reform Amendment Bill for 2018, it is not a new area of law. Law revision has existed since the 17th century in the United Kingdom. This bill that we have before us today has two functions: law revision and law reform. In respect of law revision, the scope of law revision relates to the modernizing of our systems as it relates to the revision, editing, and consolidating of our laws. The second limb of this bill, which deals with law reform, focuses on the modernizing of the establishment of a law commission and the creation of an entity which now reviews our laws in a whole and thereby provides recommendations towards reforming our many laws within this country. So as I've highlighted these two functions within this limb, it would be remiss of me not to deal with them individually, because each limb has a different function and a purpose. So we'll first focus on the law revision aspect of the law revision reform bill. Now, from the outset, this bill has maintained the appointment of the Law Revision Commissioner with a few tweaks. I had the opportunity to review the last Law Revision Act, which was enacted in 1967. That law was approximately more than 50 years old. In that legislation, there was nothing that spoke to the qualification requirement for the law commissioner. What this bill has done is created a qualification requirement whereby the law commissioner, in order to be considered, he must have standing of at least 10 years as a minimum of 10 years as a legal attorney and at least 7 years experience in legislative drafting. That is the first hurdle. In order for a law commissioner to be considered for the post, he must have the qualifications for it. It ensures that our law commissioners will be persons of good standing, good intellect, and persons who are experienced within the field and nature of law revision. Now, as I stated to you before, law revision is nothing that is new to the political and legal landscape. From as early as the 17th century, the United Kingdom recognized its importance. From 17th century, England employed persons to sit on the commission revision because they recognized that once Parliament has passed the law, unless there's an issue that arises through application or practice, Parliament may never return to that said law again. So as long as there's no issues arising from the application, that law remains in force. So with the passage of time, if no one raises any issues, that law remains on the books. So let me give you an example. You may have a piece of legislation which speaks to typewriting machines. I grew up in the era where I heard about typewriters. I don't think I've ever seen a typewriter yet. Now, if the legislation spoke to that, by all means, I believe that now is now obsolete. It is irrelevant. It's useless. We're in the era of tablets, printers, computers, laptops. There's hardly any person who uses a typewriting machine now.
I see it for citizens using it.
Now, with the introduction of the law commissioner, he would be able to review that law and take a position that this law is no longer relevant, and he can either omit it from the consolidated books or make the necessary recommendations to the AG. We are at the stage now where the law commissioner is needed more than ever. I saw in a newspaper article recently where persons were referring to that Barbados needs to become more modern with their law. Journalists were saying that they need to have the ability now to have the freedom of speech. There's a lot of issues in law that we have not addressed our mind to in Parliament. What the Law Revision Commissioner can do now for us, he can sit down, review all of our legislations, and make the necessary recommendations to the AG. The AG will then, on consideration of the Law Commissioner, determine whether or not he present that piece of legislation to Parliament. That creates continuity with the establishment of law as well. Now, the purpose of this bill, as I've indicated to you, is to improve our current Law Reform Revision Bill Act. It doesn't reinvent the wheel. As I stated to you, it keeps the Law Revision Commissioner because we recognize the importance of it. It was imparted from as early as the 17th century. There's no reason to change that. What we're doing is improving the efficiency of the Law Revision Act. We're making it a modern act. We're making it more useful to today's society. It needs to be advanced with the societal developments of Barbados. Everyone in Barbados and all of my honorable senators here can all agree that Barbados has advanced over the last 50 years. We are no longer the Barbados we were in 1967. We are now all embracing of the technological developments that has occurred in the wider world. We are all into laptops, tablets, flash keys, CDs, hard drives. None of those things existed in 1967. What this bill does for us now is allow the Law Revision Commissioner the power and capacity to take the new elements of technology, those instruments and tools which were designed specifically to make the sharing of information more efficient, less costly, and accessible. The Law Revision Commissioner now has the authority to take all of our legislation that are on our statute books and place them on the internet. There was no World Wide Web in 1967. There is one now. So we, as a modern society, have to be evolving. We cannot allow the world to continue and there's no one following the developments within the activities of the world. That is what the Law Reform Commissioner does. He's able to look at the laws in international standards, regional standards, and locally, and make recommendations for change. That is an important aspect of our legislative framework that we need, that we were missing. An example, one of the things that the Law Reform Commissioner does for us right now, that he will do for us right now once this act is implemented, is that he will now be able to consolidate all of the legislation that we've had. I heard Senator Franklin indicate that he had difficulties going on the internet and researching law, that he was unable to find certain legislation. He found it easier to find legislation in Trinidad. That is correct. I am a practitioner, and if I go on the internet now and type in certain legislation, I may be hard-pressed to find it. The Law Review Commission now has the authority now to take our legislation, place it on the internet, and not just place it on the internet, because it only fixes one problem. The other problem that exists is that if we pass law every day for the next 365 days and amend laws for the next 365 days, the Law Revision Commission now has the authority now to consolidate that information and make the reading of the legislation seamless. So that where I pull down a legislation that was made on May 1st, an amendment that was made on May 6th, and a subsequent amendment that was made on May 12th, if I did not know that an amendment occurred on May 6th, I would be using the amendment on May 1st as good law, when two subsequent amendments would have been implemented since the May 1st amendment. The Law Revision Commission now ensures that all of the legislation and amendments that were made are consolidated so that we can now have law that reads seamlessly, no more confusion. And the icing on the cake regarding this bill is that the Law Reform Commissioner will be a post in accordance with the Public Service Act. What that means is, to give you another example, the problems that we would have had in the past 9 years where nothing would have been occurring, the fact that we are now making the Law Reform Commissioner a person responsible on a day-to-day basis, we are giving him a full-time job. He is solely responsible for ensuring that the laws are reviewed, revised, and monitored. He has that one job. So it's no longer a situation where we would appoint a temporary law commissioner, as was the case with our previous legislation. This legislation gives him a full-time job, ensuring the continuity of the revision of our legislations. That is a magnificent achievement by this Barbados Labour Party-led government. Now, there's other aspects and other powers that the law commissioner has, but the legislation basically gives an exhaustive list. So I will not endeavor to go through them in its entirety. However, there are a few that I would like to highlight that I believe are of significance. Now, I touched on the fact that we've appointed the law commissioner. Some of the other powers that the law commissioner would have, as Senator Tate has continuously been lamenting on in this honorable house, is the fact that she's a stickler for grammatical errors, punctuation, proper formatted legislation. Now, if this administration now so happens to produce any other legislation of a similar kind, which may raise hairs on Senator Tate's back, we now have the law commissioner who is now there to ensure that anything that slipped through our honorable Senate, he is prepared to rectify those necessary issues that might have been raised. So, in summary, honorable senators, the Law Revision Commissioner has one simple task: review our laws, make the necessary recommendation for amendments if there are any significant changes in the law, edit and consolidate our laws so that we can all bring an all-encompassing group of legislation together that is easy to be accessed, easy to be read, and easy to be used. That is the sole purpose and scope of the Law Revision Commissioner. Now, the other aspect of this legislation, this bill, deals with law reform. Now, there's at a fundamental level, the rule of law depends on the quality of laws that are made and that are upheld. That basically means that the rule of law requires good law. The rule of law requires good law. Law reform is the process that makes law good and good law better. I saw a quote recently that I wanted to share with the Honorable Senate. I was unable to get the name of the person who made the quote, but they stated that law reform is very important to the legal system and to any country. For the law of a country cannot remain static, but must keep abreast with the political, legal, economic, and social developments of society. Invariably, there will be areas where the law is unclear, complicated, and inaccessible. One of the most effective ways of bringing about legal change or improving the law is establishing a law reform commission. And that is what we're endeavoring to do today. Enact legislation which makes provisions for a law reform commissioner. The law reform commissioner now, unlike the law revision commissioner, the law reform commissioner, sole purpose relates to the reforming the legislation. He looks at it holistically. He looks at all of the activities that have occurred on the international stage, and they make the necessary recommendations. They determine, based on the societal changes, what laws need to be curtailed, what laws need to be removed, what laws need to be amended, what laws need to be enacted. So as to give you a real-life example of how important a law commissioner is. Right now in the United Kingdom, technology has advanced to the stage where vehicles can now be self-driven. So cars can now drive themselves. No steering wheel, merely a button, press to where you want to go and it takes you there. Under our current legislation, those cars might have difficulty being placed into our society to be driven because the legislation has to provide the framework for them. That is nothing that can be done overnight because we have to understand the vehicles. We have to understand all of the aspects, the mechanics, the technology behind it, because we don't want to put a vehicle in place and someone gets in it and it drives them off a cliff. We have to ensure we have the proper legal framework to deal with situations like that. So what England has done with their law reform commissioner is giving him the mandate to review all of the laws throughout the world that relate to self-driven vehicles, compile that information, and provide a draft bill which enables the Attorney General there, or whoever is the person akin to the Attorney General, the opportunity to review that legislation and be better placed in a position that he can take that information to Parliament and have a properly well thought out legislative framework in place to be laid before Parliament. That is the job of the Law Reform Commissioner. He enhances the legislative framework in any society. And that is why we need a Law Reform Commissioner as well as a Law Revision Commissioner. Because as I explained to you before, two different functions all under one bill, but both equally important. And I am of the view, Honorable Senators, Mr. President, that this bill, as I stated earlier, is one of the steps that are needed to take Barbados to the next level and becoming a modern society in the 21st century. I'm blessed with you, Mr. Speaker.
Senator Tate.
Thank you, Mr. President. Mr. President, we had a blessing from the Bishop Designate. Today is a special day because I rise in support of this bill. So the Lord is truly in this place. It was actually a pleasure to read this piece of legislation, Mr. President, and a sight to behold. I agree with Senator Sands that it is the areas that are covered by this legislation are indeed necessary in the country and as it relates to our legislation, particularly where we have a government that is focused on fixing, reviewing, upgrading, updating. You need to have that extra covering to ensure that what you're doing is done properly. So that while there are some things in the legislation, and I beg your pardon, in the proposed bill, that I will bring to the attention of the Honorable House in the event that my suggestions can enhance the bill. Generally speaking, it is good law, and it was indeed a nice read. Mr. President, what I'm going to do this afternoon is to take you to different aspects of the bill. So I crave your indulgence as I move around, and I encourage the honorable senators to have their bill with them so they can keep up with me, so that in the event that we get to committee, we are all understanding what my humble suggestions will be. Mr. President, I start with the interpretation section, which is clause 2. And you will see there, sir, the definition for cumulative addition, which would be the second definition in clause 2. Mr. President, are you with me? Do you have your clause? Okay. So if we start there, and I don't plan to be long, but I wish to be thorough. We have a definition of cumulative addition in clause 2. But then, sir, if you look at clause 6, subclause 2, we have reference to the cumulative addition again, but the last word of that clause just makes reference to addition. For purposes of printing copies of the cumulative addition, the Law Revision Commissioner shall prepare appropriate instructions with regard to the laws which are to be removed or inserted in the addition. My training and my DNA would say, sir, that for completeness, that definition in clause 2 should be either cumulative addition, or you put cumulative with addition in clause 6, subclause 2. So that you're consistent. You have one definition, but you're using it another way in the bill. So in terms of drafting, yes, it is clear what you're referring to, but if you're going to take the time to define, you should define holistically or make the adjustment in subclause 2 of 6. I move, sir, then on to page 7 of the bill, which speaks to a law reform commissioner and a Law Revision Commissioner. First of all, sir, I would suggest that you refer to the Law Revision Commissioner first, not only because it is making reference in that area to Section 3, but also because the bill as it is drafted deals with law revision first. I am on page 7, and I'm looking at the Law Reform Commissioner definition and the Law Revision Commissioner definition, where you have the Law Reform Commissioner appointed under Section 29, and then reference to the Law Revision Commissioner appointed under Section 3. I would turn it around because 3 comes before 29, but also because the Law Revision is dealt with first in the bill. All right, now, with respect to either one, let's deal with the Law Revision Commissioner because that comes first in the bill, sir. We have a definition of the Law Revision Commissioner means the person appointed, I would have said pursuant to Section 3, but under will do for those who are not sticklers for the language. But then, sir, as you look through the Law Revision section, going up to section, very important, Clause 28, you're seeing Law Revision Commissioner and Commissioner being used interchangeably. Now, the thing about that is that this bill deals with 2 different commissioners. So I believe that for purposes of, what's the word I'm looking for? What's it? Consistency, clarity, well, yeah, and any of those was an adjective. What I would propose, sir, is that you either say something to the extent that the Law Revision Commissioner or Commissioner, or you put the words Law Revision Commissioner every time you make reference to it. It may be cumbersome, but it will be clear. Let me just bring to your attention, if you look at page 9 at clause 6, that entire page makes reference to just a commissioner. Yet we have a definition on page 7 of a Law Revision Commissioner. So you would need to either make amendment to commissioner, to the definition of Law Revision Commissioner, to include or commissioner, or you need to go through your bill and make the requisite references to the Law Revision Commissioner or the Law Reform Commissioner. In that regard, I've also noticed, sir, that in some areas, rather than make reference to the Commissioner or the Law Revision Commissioner, there has also been a reference to a he. So if you look at page 15 and clause 16, subclause 1, the Law Revision Commissioner shall make such arrangements as he thinks expedient. However, I think that's the only time that the Law Revision Commissioner is given a pronoun. In the other parts of the bill, you're getting Law Revision Commissioner or Commissioner. So for purposes of consistency, make everybody a he, make it a Law Revision Commissioner, or refer to the person as Law Revision Commissioner at all times. There'll be no room for confusion and everything will be clear. If I ask Mr. President if you are with me, would that offend you? Okay. And the leader of government business, you're with me with clause 16.1? It doesn't matter. It doesn't matter. All right. Sir, if we look at the beginning of part 2, we have an appointment of a Law Revision Commissioner. Now, Mr. President, I've read this bill. The person who is appointed the Law Revision Commissioner will have a lot of work to do. The person has a lot of power, but they have a lot of work to do. The functions are comprehensive. So, when we look now at clause 3.1 and the qualifications for the Law Revision Commissioner. Subclause A, and I'm saying clause and not section because until it's an act, it is not a section, it's a clause. Okay? Okay. You're welcome. So, subclause A says, shall be an attorney at law of not less than 10 years standing and shall not have less than 7 years experience as a legislative drafter. The thing about that, Mr. President, is that if you have somebody who can do legislative drafting but did not go to law school, you are limiting yourself when you have and instead of or. I'm suggesting humbly that rather than and, you have or. Because you can have persons who do the legislative drafting course at KPhil and go on to do a master's, but don't go to law school. If you put and, you may lose the benefit of the experience of somebody who is trained in legislative drafting, but did not go to law school. So I'm suggesting humbly that the powers that be review the and put or. And if you look, sir, at clause 29, subclause 3, you will notice that for the Law Reform Commissioner, it shall be a person who holds or has held judicial office, or a person who is an experienced legal practitioner, or an experienced teacher of law in a university. So I'm suggesting that or would be better for the commissioner. If you want an attorney at law of 10 years or more that applies and does not have legislative drafting would deserve not to hear from whoever is hiring. You cannot be a Law Revision Commissioner and don't have the legislative drafting. But what you're doing here is stopping somebody who was drafting for 20 years but did not go to law school from applying. And that person would have worked in the trenches and would have been drafting and probably may have more skill than an attorney who did it as a course. As part of, I did legislative drafting in my first year at KPhil when I was there 10 years ago, give or take. Work out the math, I ain't here? Good, okay. So I'm saying that's limiting your Law Revision Commissioner, and I think for this kind of post, Mr. President, the person should be as skilled as possible. I also noticed in subclause 3 that the commissioner shall be assisted by such staff. I was curious to ascertain what that meant in terms of numbers, how many such staff constitutes. And again, that subclause 3 makes the general reference to commissioner. We go on, Mr. President, and I go now, sir, to clause 5, subclause 3, which says, sir, I'm sorry, everybody, that's page 8. The Law Revision Commissioner may publish the revised edition, the cumulative edition, or any of the databases prepared under subsection 1 on the internet or in any other electronic format. Mr. President, I am suggesting that that may should become shall, because pursuant to the explanatory note given for this bill at clause 5, it says that this clause makes provision for the laws to be in electronic format for the purposes of publication to the internet, explanatory note, page 2, or the production of a CD. This will enable the laws to be more widely accessed by attorneys at law, the judiciary, and the public, thereby strengthening the rule of law. So I'm saying, rather than may and make it an option, I think we should use the word shall so that it must go onto the internet and therefore satisfy the explanatory note that speaks to strengthening the rule of law. And I do agree that if we have access to it on the internet, albeit with a subscription, which I would be unashamed to say should attract a cost, because drafting laws is not cheap. It cannot be for free. You will hear freeness coming from people who are not skilled in legislative drafting or who are ill-informed or uninformed. There has to be a cost. People have to be paid. And it is, you cannot minimize the skill of legislative drafting, because as I've said time and time again, Mr. President, this is a specific skill where every word, every punctuation, everything makes a difference. You have to have people knowledgeable on it. My knowledge may seem a lot to Senator Haynes. She always, and Senator Springer has offered me the job as, I shouldn't say that in his absence, but he has alluded to the possibility of me getting the job as Law Revision Commissioner. But I am not trained the way some people would be trained who actually have pursued it as a area of expertise. So that in that regard, sir, I'm suggesting that that becomes shall, and you will find that for law reform, when I get to that, the terminology there used is shall. I go on, Mr. President, I would have made reference to the use of commissioner on page 9. Mr. President, clause 7 gave me goose pimples. I was so happy to see it. This is the clause that tells you the powers of the Law Revision Commissioner. And it is dealing from everything from things that only lawyers will understand, because you have some comments here that you got to, like, in pari material. You got to look that up if you know the difference. But for me, to correct the punctuation in any law, to correct cross-references in any law, to provide footnotes, explanatory notes, or any other notes by way of application, to correct grammatical, typographical, and other like mistakes and omissions in the existing copies of laws, and for that purpose to make verbal, what's a verbal addition, Mr. President? Omissions or alterations not affecting the meaning of any law. I must confess, Mr. President, my eyes watered when I read this. I was so happy. I hope that it is not going to just stay in type form, that it actually is manifested into a Law Revision Commissioner with persons who will be working with the Law Revision Commissioner. Well, I already said I'm supporting it, so we are on our way. All I'm doing, let me repeat, is trying to ensure that the final version is the best that it can be. Mr. President, I bring your attention now to page 12, clause 8, subclause B. The commissioner, which I believe should be the Law Revision Commissioner, or commissioner if it's defined properly in clause 2, is of the view that the error is of significance. The commissioner shall forthwith advise the Attorney General of the error, and the Attorney General shall, by order to be known as a law revision order, rectify the error by setting out the required amendments to the law. So we have a reference with a specific name, law revision order. Then we get to subclause 2, and you have an order made under subsection 1B may have retrospective effect as from the date specified in the order. If you can tell me known as a law revision order in clause 181B, I would suggest humbly that reference to order in this section must be specific to the law revision order, because there's a law revision order and there's an order. If you're going to define it in clause 1B, you should be referring to it in clause 8.2 as well as 8.3, and not just calling it an order, because you are actually making reference to a law revision order. Likewise, Mr. President, on page 13 in subclause 9, clause 9, subclause 1B, the Commissioner is of the view that the error is of significance. The Commissioner may, by notice to be known as a law revision notice, rectify the error, etc., etc. Then we go into subclause 2, and notice is referred to, it doesn't even have a capital N, like how there's a capital N on law revision notice. So you either have to do the same thing and say law revision notice or notice with a capital N, and law revision order or order with a capital O, so that you're connecting the two specially named items as one and the same. Now, with respect, sir, to subclause B of 9.1, I note that the Commissioner, let me read from the beginning. Subject to section 10, wherein any error in law comes to the attention of the Law Revision Commissioner before that law is consolidated, and B, the Commissioner is of the view that the error is of significance, the Commissioner may. Mr. President, I'm not understanding if the error is significant, why the Commissioner only may and not shall. If it's significant, as a matter of fact, if you look at A, you will see that A says, if it's minor, the Commissioner shall rectify. And then we have a significance, maying. I think we need to make that shall. And when you look at 8.1b, if you go back to clause 8.1b, you will see that 8.1b also says shall. So for purposes of consistency, Mr. President, particularly so because it's a significant error, it should be shall. Okay, Mr. President, I was happy to read clause 10, that the Law Revision Commissioner actually does not have the power to alter or amend the substance of any law or provision. That was good to read. I bring your attention, sir, now to clause 11, subclause 1. Notwithstanding section 10, where in any case it appears necessary to the Law Revision Commissioner to alter the substance of any law, the Commissioner shall draft a bill. And every bill drafted shall, if the Attorney General approves, be submitted to Parliament. Mr. President and members of the Senate, take yourself to, let's turn very briefly to clause 24, subclause 4. And you will see where an omission from the laws of Barbados comes to the attention of the Law Revision Commissioner. The Commissioner shall rectify the omission in such manner as he determines to be appropriate. If you look at 4, it says an order made under subsection 2 shall be laid in Parliament, but there's no reference to a bill. I'm seeking clarity as to what was the intention of the draft persons, where there's a bill for purposes of errors, but there's not a bill for purposes of omissions, all of which are supposed to be submitted to Parliament. I just wanted to highlight that as well. I proceed, Mr. President, and I go, sir, to clause 12, subclause 2.
Senator,
yeah.
I'm reluctant to interrupt you, but you're really making the committee stage unnecessary.
Well,
reading.
Mr. President, I did ask, but the purpose of this is in the event that the leader of government business, and I'm speaking with, this is my thinking, and I also got some guidance. In the event that what I'm suggesting can be checked upon before we get to committee, then we're in a position, or a better position, to ratify any amendments. Because this chamber, these days, we need to be a little more careful when we're doing amendments and ensure that we have consensus at all levels.
But there's a place in the stage of a bill for broad principles and objectives to be discussed. That's second reading.
But I'm guided by...
There's a place for the committee stage where
yes,
individual provisions can be addressed.
Mr. President,
what you're doing now.
Mr. President, I sought advice by persons who I believe would know. And I would have also spoken to the leader of government business. And the purpose is to highlight in advance so that we know what we're doing in committee. If the president wishes me to discontinue, I would be guided by the president. But that is basically the basis of my submissions for this morning, sir. It is really to ensure that we are not... You see, Mr. President, the reality is that I personally am now not... I am reluctant to say yes to something that I'm not sure will actually be changed. And I prefer to give as much notice as possible so that in the event that something could happen while we break for lunch, for example, then persons who need to check if the amendment is okay will be able to direct the committee session with a little more certainty. The challenge is that if we wait to committee, there is no time to ascertain if the proposed amendments would be accepted, if they're reasonable, if they make sense. And that is all I'm seeking to do, to ensure that we're all on the same page by the time we get to committee, and to give those who need to the opportunity to seek counsel and clarification. I understand that it is not the debate in the true sense, but this Senate, because of our propensity to amend, I'm finding that the sooner it is out there, the better. And I see certain members of the government making notes and understanding what I am saying. Mr. President, I don't intend to be much longer.
No, I understand the considerations that inform your intervention in the manner in which you've intervened. And I too agree with a lot of what you're saying. But I continue to regret the fact that in many of these measures, a representative of the Solicitor General's Department from the drafting section cannot be present, as used to be the position in the days when I had a seat in the other place. I would often see Mr. Lewis Hunt and Sherman Moore at different stages. Draftsmen came down, took note. At times, difficulties were explained in such a manner that we were happy. On other occasions, they accepted that amendments had to be made, but never, and this is the 10th or 11th session of this Senate, its complaint has been made repeatedly, but I've never seen anyone from the drafting department in attendance. I don't know if they need a formal invitation from the President of the Senate or from the clerk, I'm not sure, but we never see them. Never see anyone, and several of the comments you made reflect the need for slight but important amendments. They're not elaborate, but for consistency and so on, some of the amendments are necessary. I myself took note of it when I was reading it, so there's a lot of good sense in what you're saying, but there's nobody from the Solicitor General's office, the legal department, in attendance. We have on several occasions made the point that someone should have been in attendance. I hope they're hearing me. I am hearing all the time that they're short-staffed, but I think there are about 7 of them. I mean, a fellow could come for 2 hours or 3. We're not debating for the whole day. Anyhow, hope someone hears now. Please.
Mr. President, how would you wish me to proceed at this time?
Yes.
Would you wish me to proceed, or you wish me to?
I got the impression that you were virtually at an end.
I'm more or less, sir, but I do have a few things more to say. If you wish me to discontinue and continue in committee, I'm happy to do so, sir.
Complete in short order, as you promised.
Indeed, sir. Very well. Thank you. Sir, as I'm looking at clause 12, subclause 2, I see that where the Law Revision Commissioner advises the ministry pursuant to subsection 1, the ministry shall, as soon as possible, take the appropriate action to increase the fee or fine. Sir, the term as soon as possible is vague, and there's no provision in the bill for non-compliance. And why this is critical is because the Law Revision Commissioner is mandated to provide a report at the end every calendar year. If he is waiting on information from a ministry who has not complied, he will then become non-compliant. So I'm wondering if the draftspersons would wish to either make provision for non-compliance for the Law Revision Commissioner or define as soon as possible. I don't think as soon as possible should be in legislation. It has no value. It has no meaning for legislative purposes.
It may be within or outside our lifetime.
It can mean anything if we really had to get specific about it. Mr. President, on page 15, as I highlighted to you, clause 16 use the pronoun instead of the Law Revision Commissioner. I note, Mr. President, at clause 17, the fines for printing or producing without the authority of the government of Barbados and the imprisonment. Seems that it may even be more than for the road traffic legislation, but we will see. Now, Mr. President, with respect to clauses 20, 21, and 22, my query is simply this, and I crave your indulgence. Clause 20, subclause 1C, outlines 8 persons who are to receive a copy of the revised edition. Mr. President, in clause 21(2), the same persons are to receive, but unlike clause 2, you have 5 persons referred to in subclause 2, and then there's no reference to the Governor General, the Attorney General, or the Law Revision Commissioner. I don't think it can be that those persons will not wish to have sight of the documentation referred to in clause 21. I'm suggesting that there should be consistency in the drafting. You have itemized from the Governor General down to the Chief Archivist. You've actually made a reference to 8 copies at subclause 20, clause 20, subclause 1A. But then in subclause 20, then in clause 21, subclause 2, you have taken out the GG, the AG, and the Law Revision Commissioner. Likewise, sir, I don't know if there's any significance. Perhaps it could be explained. In clause 20, subclause 3, if for any purpose a copy of any law contained in the revised edition is required to be certified, the Clerk of Parliament or the Law Revision Commissioner shall insert in a copy a certificate, etc. But in clause 21, subclause 3, it seems as if only the Law Revision Commissioner can certify. Is that supposed to be so, or is it an omission of the Clerk of Parliament at clause 21, subclause 3? Likewise, for subclause 4, it seems as if only the Law Revision Commissioner can certify. I don't know what it means that the Clerk of Parliament is out of it. There may be a reason. I'm just seeking clarity. With respect to clause 22, we have at clause 1, subclause 1, the list of 1, 2, 3, 4, 5 persons that would be given updated laws. And then in subclause 3, you have tacked on the Governor General, the Attorney General, and the Law Revision Commissioner. Again, that's not consistent. Same people, but referred to in 3 different ways. Because you have the Governor General, the Attorney General, and the Law Revision Commissioner in clause 22, subclause 3. You have them listed in clause 20, subclause 1C, and you don't have them mentioned at all. 3 of them are not mentioned in 21, subclause 2. I'm asking that the inconsistency in drafting be rectified so we know who getting what. And so the thing about it is these things are they're more obvious when it's 20, 21, 22. You can't help but notice that there's inconsistency in drafting. Yeah. With respect to subclause 23, I'm suggesting, Mr. President, that because this speaks to where an act is repealed and replaced, but the subsidiary legislation made under the former act continues in force, and the Law Revision Commissioner is of the opinion that the subsidiary legislation is substantially in conflict with the new act, the Law Revision Commissioner may, in writing. He shouldn't, if it's a substantial conflict, it should be shall and not may. Again, we have in subclause 2 of clause 23, as soon as possible. And with respect to the report every calendar year, sir, that is clause 27. Sir, at clause 27, subclause 2, the Attorney General may cause the report referred to in subsection 1 to be laid before Parliament. However, at clause 34, subclause 2, he shall. So if it's a report and it should be going to Parliament, I would suggest that it should be changed from may to shall, which makes it consistent with clause 34, subclause 2. And if I could just go back, sir, with clause 26, the Attorney General may, on the advice of the Law Revision Commissioner, appoint suitably qualified persons to assist the Law Revision Commissioner. What does suitably qualified persons mean, and how many people can be hired? Is there any limit? I'm just suggesting because it's legislation and you should be specific. My reference is clause 26, subclause 1. Now, Mr. President, at the end of 28, we then go on to the law reform section. But before you leave the revision,
you feel that strongly about the limit being included there?
I'm asking. I'm happy with this bill. I'm just asking for clarity. It's up to the draftspersons and the government. It just seems to me that since there's going to be compensation, and by the way, senators, clause 32, subclause 3 says the Attorney General may authorize the payment of compensation and expenses to persons consulted or appointed under this section. This section deals with consultation of persons and appointment of specialized committees. It would seem that everybody gets compensated for working on committees, except in the Senate.
That's part of your public service.
These two, sir.
The fullness of time you'll be rewarded there as part of your public service.
Mr. President, if I can draw your attention to clause 31, subclause 3, which says that in the exercise of the functions prescribed under this act, the law reform commissioners shall be subject to the general direction of the Attorney General. I didn't notice any such type clause with respect to the Law Revision Commissioner. I don't know if that was intentional or not, but the Law Revision Commissioner will not have direction from the Attorney General. I'm not certain if that was the intention. There's no general direction of the Attorney General in relation to the Law Revision Commissioner. There is, however, general direction for the Law Reform Commissioner. I don't know if there's any significance in one having general direction and not the other, but I would want that explained or clarified.
That creature must be guided by someone.
The Law Reform Commissioner, but not necessarily, well, wouldn't the Law Revision Commissioner need guidance as well, or less so? There may be an explanation. I just noticed the difference, and I'm seeking to highlight it in case there is an explanation.
Well, before we get an explanation, it sounds to be an omission. It appears to be an omission.
You're saying that on your mic, sir? It sounds like an omission? Okay, thanks. Finally, sir, and I know that everyone is sighing with relief, but the leader of government business encouraged me to speak now. I would say generally, sir, subject to the proposed and suggested amendments. It is good legislation, and once followed, it can enhance our legislative situation in Barbados by leaps and bounds, particularly in our environment. I would like to say, if I may, just as how Senator Franklin is asking for specific attention, I would suggest that very high in the totem pole, there's a review of the employment rights legislation, that there's further review of the family law legislation, and I believe that Senator Maynard would wish me to make mention of legislation dealing with organ transplants. With those few words, Mr. President, I am very obliged to you, sir.
Thank you.
Mr. President, I beg for this session be suspended until 3:30 for lunch.
We propose that we now stand adjourned until 3:20, 2 hours of lunch break. 3:30, sorry. All those honorable members in favor, please say aye. Those against, please say no. I think we can all do with lunch. The ayes have it.
therefore want to offer my very best to the Bishop Designate and to give him the assurance that he has my full support in any way he so requires. But getting back to the substance of the bill that is before us, I think it is important that we support this bill. It is, in my view, sir, very timely. As I indicated, the law does provide boundaries for members of society to function. It does communicate to members of society what is right and what is wrong. And it is important that the general populace has access to the laws. And I heard Senator Boyce in his speech referencing the fact that this legislation would facilitate access to the law on your device. And I think, sir, that is very, very important. It is important that our citizens have access, and that the focus of the law, which is in ensuring that there is justice and ensuring that there is fairness, that, sir, is achievable, and that it is allowed through the ability of the citizens to be able to access the law. So I certainly support that. Of course, we know, sir, that information communication technology has certainly revolutionized the world, and that we have to ensure that as we function in this modern era, that we are able to do so by being cognizant and embracing those elements that are positive and that are good and that would assist us in helping to transform. So it's important to have access to the laws and to be able to make reference to law. As we know, sir, law is not something that is static. It is not something that can remain at a standstill. Law is a living element, and it is also important that while there are laws on the statute book, it is important as well that persons are able to access the benefits and the rights through the law. Sir, I remember there was a situation in Trinidad, I believe, with a Trinidadian Calypsonian in the 1940s. That Calypsonian sang a song about rum and Coca-Cola. Yes, I heard that, sir. No, I was not around. That is a fact. I was not around at that time. But I'm told this Calypsonian sang a song about rum and Coca-Cola and how good it was. And Coca-Cola at the time thought it was a good song. And they embraced the song without giving any recognition or paying any royalties or anything to the Calypsonian. And the Calypsonian did not have the resources to be able to have his case represented. And that's why I made the point that it's important, while we have laws that access by all Barbadians to the benefits that come from the laws, that is important. Of course, in that case, sir, there was a situation of Trinidadian businessmen assisting that Calypsonian, and he did, in fact, have an opportunity to achieve from Coca-Cola the benefit that he was deserving. So the law is there to help facilitate and to provide greater justice. And I think this bill certainly recognizes the need to ensure that changes to our law occur in a timely manner. Of course, sir, over the years, things change. If I could reflect on Coca-Cola again. When I was 6, 7, 8, 9 years old, and you made reference to Coke, it meant Coca-Cola. In today's world, when you make reference to Coke, it doesn't necessarily reflect Coca-Cola. It could probably reflect an illegal substance as well. And the point that I'm making is that the norms and the values and the culture of and subcultures of society changes. And law as a living element also has to change and also has to be transformed. Of course, sir, we have to be able to ensure that we have good and proper order in society, and that those persons who are in any way aggrieved, that they are able to seek their day in court. And while I speak, sir, to the access, I also must spend a few minutes speaking to enforcement of our laws. Sir, there is a level of deviant behavior in this society that is not good. You know, I have to tell you, sir, that I fully embrace the need for people to express themselves. I don't get too caught up with things like fashion. I remember again when I was a younger fella, I used to wear some bell-bottom pants. I would not wear them again, sir. Some bell-bottom pants and some platform shoes. I remember them, and you got an afro and thing, man. I remember those days. I will not go back there. Even if that fashion comes back in, I will not go back there. But no, I can't. No, I can't. If I wanted to get an afro, I would have to get a wig, sir. I can get an afro now, even if I wanted to. But the point is that I think that there are some elements that should not change. Respect for law and order, I think, is very important. And you know, we talk very often about having rules and having the laws in place, but the enforcement of our laws is not always undertaken. And I want to take this opportunity to appeal to those who have the responsibility for enforcing the laws to do exactly that. Of course, sir, you know, you do have to sometimes to temper justice with mercy. And, you know, there are situations where people may be in breach of some element, but you don't always have to come down with a heavy hand. I remember a situation, sir, years ago. I was in my mid to late 20s, and I got a call from what was then Grant's Drug Mart in Oistins. My cousin was calling me and asked me to come there immediately. And when I got there, there was a youngster who was held. He actually took up something from the pharmacy, and my cousin held him. He escaped, and he literally ran through the glass door. And my cousin went through the glass door after him. And he held him. The police was called. And so by the time I got to Oistins, there was this big commotion. And his father was there. And the father said to me, I want you to give him a break. I can deal with him. And he was shaking. And I decided, sir, the only thing that I needed to be done was for the door to be repaired, and that I would allow that youngster an opportunity. And I said to the police we would not be pressing any charges. I have to tell you, sir, that that young man is a good, upright citizen today in society. And the point is that sometimes we make errors. All of us make errors. You know, Senator Reverend Maxwell knows me from the Christ Church Parish Church. I would like to think that I have in some way influenced them, not necessarily with what you should do, could be in things that you should not do. You know, but the truth is, the truth is, sir, that we do have to ensure that as we enforce laws, that we have that human element to be able to provide opportunities to assist people, because sometimes all of us make mistakes. I certainly made some. In fact, again, Senator Maxwell would remind me that We all have sinned and fallen short of the glory of God. If we say we have no sin, we deceive ourselves and are strangers to the truth. And it is important for us to be able to forgive individuals and to allow them the opportunity by reflecting on some measure of mercy. Mr. President, Barbados is certainly a tourism destination that is seen, that is safe and secure. And part of that relates to the fact that when compared to some other destinations, we are not a high crime kind of destination. And I think it is important for that to continue. Of course, we have to ensure as well that the support is given to the persons responsible for policing the destination, because the reality is that when you are speaking about the laws, the police play a critical and important role, and we therefore have to ensure that we are able to provide the police with the necessary resources. I certainly, from where I sit as CEO of the BHTA and with my colleagues at the BHTA, we do our part. But it is very important that the police are properly equipped, and it is not always, sir, about hard policing. I remember some years ago that there was quite a bit of emphasis that was placed on community policing. You know, without being knowledgeable of any studies, I would guess, sir, that when we look at the level of criminal activity that is taking place in Barbados, when we look at the gun-related activities and the gun-related criminal events, that a lot of that is probably located in particular areas of Barbados. And it is important for us to be able to reach out. It is important for us to have a clear understanding of what the sociological constraints are, and for us to design within our system with the relevant agencies the ability to be able to engage persons who believe that they are disadvantaged. There have been times, and it has happened, sir, in this country, when the law has been used against the citizens of the country. It certainly does not happen in these modern times. But there would have been times when there have been laws on the statute, you books, sir, which have made people feel disadvantaged, whether for gender, whether for race, and have created elements of injustice. And I think, sir, that it is important for us as we look at policing, as we look at those communities that are significantly impacted with crime, and those communities where serious crime in particular occurs, of finding ways to reach those persons in those communities. I think, sir, that is critical and that is important, because when people believe that they're being disadvantaged, when people believe that they do not have a voice, that is when you start to get some serious challenges developing in the country. So I want to embrace this piece of legislation. Of course, it is important from an investment perspective that the law is very transparent, that persons, whether they're domestic or international investors, have a clear understanding of what is required in terms of health, what is required in terms of labor, what is required in terms of taxation and those types of things. And I think that having this piece of legislation in place, what is embodied within this bill, would allow, sir, for a regular update to to our laws. The truth is that we still have on our statute books elements of law that are still somewhat archaic and in some instances in conflict with some of the conventions and treaties that we have signed. And we have to ensure, sir, that we are able to get all of our laws properly up to date and functioning. There's that general duty for us to ensure that our laws conform with those international treaties and conventions that we have signed. So, Mr. President, I am very happy today to support this bill. I did listen on my way here to some contributions that were made, and I'm very happy to know that the independent opposition senators also, I'm so sorry, sir, independent and opposition senators, sir, just a slip of the tongue there, that the independent and opposition senators are also very much in support of this legislation, and therefore, sir, with those few words, I give my full support to this bill. Thank you.
Thank you, Senator Grant. Senator Moore.
Mr. President, I move that further consideration of this resolution be postponed seen a day.
Further consideration.
Be postponed.
Until the day appointed or unappointed? The question is that further consideration of the bill before us be now postponed. All honorable members in favor, please say aye.
Aye.
Those against, please say no.
That brings to a close government business for today. I move that it be postponed, sign a day. Adjourned, sign a day.
The question is that this sitting of the Senate be now adjourned. Sign the day before the day appointed? Yes, before the day appointed. Yes. All honorable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.